Audio.
Okay,
Oh, there we
I
go.
think we're unmuted. And thank you for you guys for putting those in the question box. As I was speaking, what I was saying was bear with us because we anticipate technical difficulties, and hopefully that glitch is the only one we'll have today. We're going to present the Rental Housing Late Fee Fairness Amendment Act. It is a clunkily named law, and we're going to take you through it and sort of talk about what you need to know as property managers in terms of how late fees are assessed. My name is Billy Cannon. This is
Brian Dorwin.
And we make most of the DC court appearances for our landlord representation group at Offutt Kerman. So without further ado, I'm going to click through our PowerPoint to get you guys a little bit of information. So to start off, the practical thing from your perspective is that this new law is an amendment to the Rental Housing Act of 1985. And the act, as you guys may or may not know, is really the law in DC that governs most of the things that occur between landlords and tenants. These amendments will generally limit a landlord's ability to charge late fees. They'll also provide very specific instructions on how those late fees can be charged, as well as penalties for a landlord's non-compliance. Our plan today is to go through the law step by step and offer some recommendations that we think will help you to comply with the law and get through what we anticipate will be a little bit of a difficult process as this law becomes the law in the District of Columbia. So the preamble, Brian, you want to do this and do the preamble?
Sure. As Billy mentioned, the law here is amending the Rental Housing Act of 1985. It's an old law, and this is a new part of it. The preamble to the law essentially is the law's introduction. It's the introductory part, stating the purpose of the law and a few of the things that it imposes. One of the first things that it talks about is a limitation of the amount of a late fee that a housing provider or landlord can charge to a residential tenant. It establishes a minimum grace period, which we'll get to, of the first 5 days of the month. And it also prohibits the housing provider from charging interest on a late fee. Not everything in this law is new, but there are some major provisions that are going to change the way we practice. The preamble continues. As I said, one thing that's going to change the way we practice is prohibition on the deduction of any late fee from a subsequent payment of rent. Most people here, and we are familiar with first in, first out accounting. This law will change that application insofar as late fees are concerned. It also prohibits the imposition of a late fee more than one time on each late payment. Billy will get to an example of that in a little while. And it prevents the eviction of a tenant on the basis of non-payment of a late fee. We'll also include a further discussion of that in our recommendations. Yeah, two more slides on the preamble. The imposition of a late fee cannot occur for payments for which a subsidy provider is responsible. That's something that most of us are probably familiar with already. And there are penalties established by this law for landlords who violate its terms. The basic overview of some things that are new and not so new: can't charge a late fee until the 6th. Late fees are limited in the amount, and it's unclear exactly how limited. We'll get to that in recommendations as well. Future rent payments cannot be applied to old late fees, which is a major change for most landlords. And the penalties for landlords for noncompliance, that's also something we'll get to in recommendations.
So the late fee limits are that the landlord cannot charge any more than 5% of the full amount of rent due by a tenant. And from the preamble, the language, obviously the intent of the bill is to limit the amount of a late fee a housing provider may charge for the late payment of rent. The important practice pointer here is that the bill is not clear what exactly this means, so it's our feeling that the courts will have to sort out what exactly this means. A prior draft of the bill made it clear that late fees were limited to 5% of the amount still due from the tenant at the time the late fee is charged. So the example that I've got on the screen there is a tenant with $1,000 monthly rent pays $900 on the 5th. The question, I think, for all of us and for the courts will be, how much can a landlord charge on the 6th? Is it 5% of the $1,000, $50, or is it 5% of the $100 remaining due, $5? The answer remains to be determined. Brian and I can tell you that we're 100% sure that tenants' attorneys will argue that the answer is $5, and that the intent of the law was to limit the amount of the late fee so that it's only charged on the amount that's due at the time the late fee is charged.
So there is a minimum grace period that's been established by the law. This is pretty clear, and it doesn't really change the practice of most landlords. A late fee cannot be charged until 5 days after the rent payment is due. If for some reason your lease says that rent is due on the 5th of the month, that means it's after the 10th. I have not seen leases like that, and I think most people, rent is due on the 1st of the month. So practically speaking, late fees can't be charged sooner than the 6th. And as I said, this isn't a big change for most landlords.
Right. So just so it's clear, I think if your lease says that you've got a grace period until the 10th, I don't think that you have the ability now to change that unilaterally. You may want, after reviewing all of the materials here, to change that in subsequent leases. But if your lease says that rent is due on the 1st and it's not late until the 11th, then you're providing a longer period than this law requires, and that's completely fine.
Oh, that's a good point.
Yeah, you're well within your rights to do that, but I don't think that the change to this law permits you to shorten the time period that a tenant has under the lease to pay the rent. One important point here in the law is that the law sets up what I will call a condition precedent for collecting any late fee, and it reads: a housing provider may only charge a late fee if the written lease agreement between the housing provider and the tenant informs the tenant of the maximum amount of the late fee that may be charged pursuant to this section. This is frankly a serious practical problem for almost every landlord in the District of Columbia, because almost no late fees, I would imagine none of the leases, contain the specific provision with regard to late fees that is set forth in this law. What our recommendation, and we're going to give it to you in a little bit more detail later, will be is that you provide an addendum to each of your tenants, and you offer it to them, you ask them to sign it and return it, you volunteer to countersign it and give them a copy. If they don't sign it, there does not seem to us to be any ability for you to make them sign it, but the offering of the addendum to them, which tracks the language in the statute and sets up the amount of late fees, will give you, we believe, the ability to make an argument down the road that you are entitled to charge the late fee because of your offering of the addendum. And of course, you should also change the late fee provision in any new leases that you're offering to tenants after the effective date of this law, so that the language in the statute is tracked and late fees can be charged.
The first prohibition that this law will put into effect is the prohibition against interest on late fees. Colloquially, we would refer to this as late fees on late fees. There, in some circumstances, are compounding late fees that are charged throughout the course of a month while the balance remains due and owing. It's not completely prevalent, but this law will do away with that practice. So you'll want to make sure that when a late fee is charged, it's only charged once.
And just so we're clear here, this law has got about, as we see it, 5 prohibitions on landlords, 1 penalty, or a description of 3 penalties really that can be assessed to landlords, and then 1 recommendation for landlords to try and collect these late fees, which you will see is completely impractical and unworkable. The second prohibition is that a landlord can't deduct the amount of a late fee from a subsequent rent payment. Brian referenced this earlier. I think he called it first in, first out. I call it sort of applying payments received to a tenant's oldest balance first. This practice is now prohibited. And this, I think, will be one of the most difficult things for landlords to get used to and to incorporate into their billing practices for tenants who routinely pay rent late. And the example, I think, on this slide makes it fairly clear. Tenant with $1,000 monthly rent pays rent on the 10th of the month, but does not pay the $50 late fee. The next month, the tenant pays $1,000 on the 2nd. So I think prior to this law, what that would mean was that the landlord would take the $1,000 and would apply it to the $50 late fee from the prior month, and then the additional $950 to the rent for the subsequent month, and would then send the tenant some sort of an informal notice reminding the tenant that they still owed $50 in rent for the month they had just paid. Now, well, once this law becomes effective, that $1,000 cannot be applied to satisfy the prior month's late fee. And we'll get, as we move through the slides here, we'll get to some recommendations, although frankly we think there will be growing pains here and it'll be difficult here.
Prohibition number 3, only 1 late fee per late payment. I got ahead of myself on the last one I'm seeing now, as Billy pointed out. So this is the prohibition that would prevent multiple late fees being charged based on a tenant missing 1 month of rent. It seems to prohibit specific provisions in some leases that, you know, not everybody has these, but they are out there. That would allow additional late fees to be charged as the month progresses. For example, if a tenant fails to pay $1,000 for rent, and the landlord charges $25 on the 6th and then $5 each day for the next 5 days while the balance is still pending, that's no longer permissible.
Yeah, and I don't think that applies to very many landlords, right. But we have seen some leases that have a sort of a sliding scale of late fees, and that's no longer allowed. It's going to have to be one or none. Fourth prohibition is that, and this I think sounds probably worse than it is. The fourth prohibition in the lease says the landlord cannot evict a tenant on the basis of non-payment of a late fee. From a very practical sense, this is already the law in the District of Columbia. When you file your failure to pay rent lawsuits, as you probably know, the court insists that late fees be reduced from whatever your lease says they are to $10 per month. And the reason for that is that the Landlord-Tenant Rules Committee and the civil rotation judges have gotten together and have decided that while the landlord may incur some hassle and some minimal additional cost because rent is paid late, that $10 a month is an amount that's sufficient to compensate the landlord for those hassles associated with the late collection of rent. But what this language does, I think, is it takes that practice and it extends it a little bit, saying that an eviction on the basis of non-payment of a late fee is prohibited. And I've included the additional language there. It's added to Section 501A of the law. The question, I think, for us as attorneys who represent landlords and for you as landlords is, what will the court do moving forward with regard to late fees? Will the court eliminate them entirely from agreements or from the notices that we file that set forth the amount that tenants must pay to avoid being evicted? Will they continue to keep them at $10 with the understanding that should a tenant satisfy the amount less the late fees, the case is over? Or will they, I mean, this is maybe a pipe dream, but permit 5% late fees based upon the monthly rent consistent with this new law? And that's something that will have to be worked out in the courts, and that frankly may vary a little bit from judge to judge. But my guess would be that at some point the judges will get together and get some sort of a coherent practice with regard to those late fees.
The last prohibition that we're going to talk about here is prohibition against the imposition of late fees on a tenant for a late payment or non-payment of any portion of rent for which a subsidy provider, rather than the tenant, is responsible for paying. This really isn't too big of a development. It's not new. We will want to make sure, though, that probably the ledgers are broken out so that you can clearly see what the tenant is responsible for and what the subsidy is responsible for in order to calculate that 5%. It's not a controversial part of the law, but as the PowerPoint points out, we'll want to make sure that we're wary of subsidy providers other than the housing authority. Billy and I have seen kind of an uptick in the number of cases with non-housing authority subsidy providers and some issues with non-payment or habitual late payment from those providers.
Right, so I think it just, as Brian said, I think it just makes sense to be aware of this and to make sure that we're putting a little bit of extra scrutiny on where the rent's coming from and what portion our tenants actually owe. So the other thing that the law does, in addition to the 5 prohibitions for landlords, is the law provides for penalties for what the law calls knowing or willful violation of the law. If there's a knowing or willful violation, a landlord is liable to the tenant for the amount by which the late fee charged exceeds the allowable late fee. So if, on our example that we've been using, the rent is $1,000 a month and you charge a 10% instead of a 5% late fee, you would be liable to the tenant by $50. You would charge $100 instead of $50, and you would owe the tenant the additional $50 because you charged the tenant that late fee and you sought to collect it from the tenant. If bad faith is found, as with most laws in D.C. as they pertain to landlord and tenant relationships, you could be liable as a landlord for treble damages, triple the amount that you sought. So in the example that we've used, $150. And if bad faith is found, and if a court finds it, you could be subject to a civil fine of at least $100 and not more than $5,000. So the council is granting the courts broad discretion to determine, I guess, the extent of bad faith, should there be bad faith found, and what the fine should be consistent with that determination. So the question, I guess, that this whole law and these prohibitions raise is, how then does a landlord actually collect a late fee?
The law does not foreclose other avenues. It says a landlord may proceed as follows. It's unclear exactly whether these are going to be effective. I'm sure most of you can probably imagine how effective an invoice for a lawfully imposed late fee might be, but that is one option that the law gives us. After the grace period expires and the late fee is charged, the landlord may issue to the tenant an invoice for any lawfully imposed late fee to be paid within 30 days. That's something that it's a little bit amorphous, and in practice, we'll want to make sure that the invoices are proper. We'll talk about that in recommendations. If the tenant does not pay, the landlord may deduct the amount of any lawfully imposed late fees from the tenant's security deposit at the end of the tenancy, along with anything else, of course, that the tenant may have done to the unit, or if there are other charges or outstanding rent to be applied to the late fee as well.
And this is, of course, ineffective for landlords.
Right.
as you guys probably know, if you've dealt with us, if you've come to any of our seminars before, leases in the District of Columbia are essentially life estates. So a tenant could, for example, sign a lease in 1987 or 77 and could still be residing in the exact same building based upon the exact same lease today. And so it's easy to envision a scenario in a long-term tenancy where the late fees eventually exceed the amount of the deposit that the tenant has provided at the time he or she moved in. The use of the word may in the law is, we think, important because it permits the landlord to take this avenue to collect late fees, but it doesn't say that the landlord must do this in order to collect the late fees, and we believe that because of that language, it doesn't foreclose the landlord's ability from perhaps attempting other remedies. And we'll talk about those a little bit as we go along.
We have a good question.
All right, question, does the law address maximum amount landlord can charge for a bounced check or only the late fee plus service charge? The law does not address the maximum amount a landlord can charge for a bounced check. Our recommendation with regard to bounced checks, and this has been our recommendation for a long time, is that you pass along your actual cost, that you don't try to use a bounced check as a money-making device, but that you take the charge that you are charged by your financial institution and you put that charge directly on the tenant's ledger and charge them for it. We think that that's incredibly defensible and that the attempt to make money off of a bounced check would be seen in a bad light by the courts. The law only addresses late fees, and the late fee and service charge, I'm not sure that I understand. I mean, I think the problem that some landlords may have with this law, or one of the problems, is that the entirety of the late fee is now capped at 5%. So if heretofore you were charging a late fee and built into that late fee amount was some sort of a service charge, then that service charge and that late fee are now capped at 5%. So that's the law in DC right now. Another question, are there any apartments that are exempt from the 5%, or does this apply to both market rent apartments and rent-controlled apartments? There are not exemptions here. This applies to all apartments in the District of Columbia. So this is a big change. Obviously, market rate rental apartments will have higher rents, and the 5% that they're charging will be more than those rent-controlled apartments. But this applies to all apartments in the District of Columbia, which we think is why it's so important that you guys get ahead of this and make sure that you understand it and put procedures in place to help yourselves to comply.
And I think we got some clarification on the service charge there. We were talking about the bounce check fee, which, as Billy said, pass along the cost that your financial institution imposes on you.
All right, so we mentioned this earlier. Open question. Can a landlord charge 5% of full monthly rent amount when a tenant makes a partial payment? We know that the tenant's attorneys will argue that late fees can only be 5% of the amount due at the time the late fee is charged. However, that's not what the law says. The law says a housing provider may charge a late fee of no more than 5% of the full amount of rent due by a tenant. So I think until we have direction otherwise, our recommendation is going to be that you charge, to go back to our example, $50 on a $1,000 monthly renter, even if that renter has paid $800 of the monthly rent by the time the late fee is charged. That may change as we get into court after this law becomes effective. We may get some guidance from the courts on their interpretation, and it frankly may take a couple of years for this to be there to be a more definitive answer on what can and cannot occur here.
I think we had one question about whether or not leases need to be changed to reflect the new late fee amount. Yes, they will.
We'll get to
that in recommendations.
Yeah, we will cover that. Another open question, is the landlord remedy limited to deduction from a security deposit? So we went through that whole process of how the landlord actually collects late fees under this law. The landlord sends an invoice, waits 30 days, and if the tenant hasn't paid the late fee pursuant to the invoice, the landlord can, at the end of the tenant's tenancy, deduct any lawfully imposed late fees from the tenant's security deposit. It's not clear whether or not that's the only remedy. It is clear that an eviction can occur because of failure to pay late fees. It also is clear, I think, that the law means landlords should send invoices to tenants who fail to pay late fees. But we think that there's an ability perhaps to utilize the small claims court in the cases of tenants who are perhaps, excessively habitual in failing to pay late fees. The other thing that we're going to recommend is that the invoices should be sent. The law says that the landlord may do this. We think it's a good practice based upon this new law to send invoices to tenants who fail to pay late fees, asking them to pay in 30 days. So we did have a question.
Questions are flying in now.
We did have a question on the effective date, and so take a look at this slide 20. So what we're looking at in terms, we use an online bill tracking system for the District of Columbia, and we're looking at December 30th per the council bill tracking. It's been transmitted to Congress, but the wheels of justice, not only the wheels of justice turn slow, but we know that things go very slowly in Congress. So Congress has this as of October 25th. And the bill tracking software that we're using is projecting December 30th as the effective date of this law. I think in order to get out in front of this, we're recommending a December 1st implementation date for our clients, just so they have the ability to try this out, try and get it right before there may actually be a penalty associated with their violation of the law. Any questions we need to take? Can we delete
we should we'll start doing some questions here while we're going through.
Oh, there we are.
First one, our current lease agreements only charge $25 for late fees. I assume I can charge the lease agreements going forward 5% for new tenants. Is there any way to go back and get that 5% charge on existing lease agreements? Will this require new leases, or can we send out a building-wide notice? Yes, we'll cover that more extensively here in just one moment. We're going to suggest a lease agreement, and if we can get this slide moved over to the next one here. There we go. Lease addendums. So for anybody asking about the going back and getting this 5% charge, as Billy touched on earlier, for any of our clients that are in need of an addendum, we've worked on this, we've thought about it, we've passed it around. We have ideas that we think will work regardless of whether or not tenants actually sign them. Now, the problem with a tenant refusing to sign an addendum agreement is obviously that they get to court and they say, I got this addendum and the notice, but I didn't agree to it, so I shouldn't have to pay the fee.
Yeah, and so the question about the $25 late fee, I think, is difficult because I don't think that this law permits you to increase your late fee with a unilateral addendum.
No.
We think that the addendum is useful for landlords who impose a late fee that's in excess of 5%. So even if it's a flat fee of $100 and that's more than 5% of the rent, or if it's 10% of the rent, we think that offering the addendum to tenants that says their late fee will going forward be 5% is effective and makes it okay for the landlord to start charging 5% in the future. But I don't think that if your late fee is a flat $25 or $20, that you can increase the amount of the late fee with an addendum to the tenants. Now, if they sign it, then I think that may be a different matter. And
Right.
certainly, I think for future leases, you're going to want to incorporate that language. We have the addendum, as Brian said, and our clients should contact us after this for a copy of the addendum that we think will be effective in getting your tenants to the point of compliance with the law. All right, security deposits. This is an important point, especially I think in a lot of market rate units, new construction apartments. A lot of times tenants are being accepted without security deposits. One of the things that we read this law to really mean is that you now have to ask for a 1-month security deposit from each tenant. Even this is not your common practice anymore. There's too much uncertainty regarding the ability to collect late fees, and it really means that each landlord has to obtain a full month from each tenant, as that security deposit, frankly, may be the only way that you can, as a landlord, obtain unpaid late fees.
Next recommendation for people using software. Most institutional landlords and most landlords generally now use software which automatically charges late fees, whether it's 5% of the balance due or whether it's 5% of the monthly rent or just some flat fee. We'll want to make sure to get in touch with software providers if you have them to ensure that nothing being charged by the software on an automated basis is going to violate the law, because you'll remember that there are penalties simply for being charged for overcharging these late fees, regardless of whether or not you're doing it consciously or via software.
Yeah, and just to go back, I mean, there's still a lot of questions about whether or not new leases need to be done. So we think that the addendum is, at present, for anyone who's charging 5% or more, we think that the addendum is what you need to do. So that you can give yourself some protection and some cover should there be a challenge from a particularly litigious tenant about whether or not what you're doing complies with the law. I think that offering the addendum to the tenants gives you the ability to argue that you've tried to comply with the law, and it's only because of the tenant's decision not to sign, perhaps, that you've been unable to do so. So the other thing we recommend, or one of the other things we recommend, is that you file monthly. Look, this is, we think, always a good idea. We think it's obviously much easier to handle and resolve a case with a tenant where the amount owed is 1 or 2 months as opposed to 3 or 4 months. But as the jurisprudence around this law develops, and it will, I mean, the courts and individual judges will make decisions sometimes in conflict with each other that will relate directly to the ability of a landlord to obtain late fees in 5%, $10, $0. It'll be particularly important to get tenants who are late paying or non-paying into court. And frankly, at least while this law is being implemented and sorted out, it may mean that you have the ability as landlords to obtain more in late fees than you would otherwise for a little while. I mean, I think it'll be our practice to still ask tenants to pay late fees as part of settlement agreements and payment plans because they've agreed to do that under the lease, and there's nothing in this law that prevents them from agreeing to do so. It would prevent us, of course, from evicting them if they fail to do so, but at the point of agreement, that's not what the court's considering.
I believe we had one question come in there. Reconfirm the effective date.
Looks like December 30th, but we don't know yet. Congress has the right, since the district is not a state, Congress has the right to comment or interfere with this law. We don't know that they will. We don't think necessarily that they will, but Congress has the right to get involved here and prevent this from being effective. But assuming that they don't, our tracking software believes that it's December the 30th.
It's probably a best practice to go ahead and start making the moves that are necessary, though, particularly if you have software providers that you need to speak with, just to go ahead and get the process started. It could be a lengthy one, depending on what your system is set up for. One other question: if an existing tenant refuses to sign the addendum, can we still charge the late fee?
Our belief on that is yes, so long as you've offered it to them. And you know, we're happy to have discussions with you guys about the best way to do that. I think that every property is a little bit different in terms of the way that they communicate with their tenants. If you have an online portal, if you have, you know, an email communication system, then that, frankly, may be the best way to communicate the addendum. We're probably going to encourage you to take what I would call a belt and suspenders approach, so that if, you know, online is the preferred method of communication, you do that, but that you also hand deliver it to the tenants, so that, you know, you're sure that they're actually getting a copy of it slipped under their door or placed into their hand. Again, just, you know, protecting ourselves and putting ourselves in a position to be able to make, you know, the argument that you attempted to comply, you attempted to change the lease so that it's consistent with what this law requires. Final recommendation, almost final recommendation. Pay attention to your tenants on this. If a tenant comes to you complaining about late fees, take it seriously. Instruct your staff, train your staff, let them know that late fees starting December 1 are something that need to be handled in a more careful manner than perhaps they have been in the past. Scrutinize the ledger. Offer to sit down with the tenant and go over the ledger and make sure that the late fees that are being charged are consistent with District of Columbia law. Before this law, it was fine to permit automatically charged late fees to continue to accrue if a tenant had any balance. With this law, that's clearly no longer the case. And that's probably the most alarming thing, and the opportunity for mistake, where the opportunity for mistake is greatest. So make sure that you're taking your tenants seriously when they're coming to you and complaining about late fees, and taking the time required to take a look at the ledger and make sure it's accurate.
I have one other question here, it looks like. Do we need to back out late fees?
It's a question from Pete Kelly. Thanks, Pete. Just so everyone is aware, Pete likes my vest. This is my professor vest, Pete. Great. I'm wearing this today because I'm in the mode of instructing. What do we do about tenants that are currently being charged late fees on top of late fees? Do we need to back the late fees out? I think that, generally speaking, late fees on late fees is not a good practice, but at this point I would say that it's best to stop that practice moving forward, and rather than go back and essentially try to unwind what's already been done. If a tenant comes to you and complains about what has been done, or the late fees and their accrual over time, then I think we can handle that on an ad hoc basis. But you know, at this point, we want to just start implementing the law maybe December 1st if possible.
Also, it's probably relevant whether or not some of those fees have already been paid. If they've been charged and paid by the time we get to court, it's our general practice not to back them out.
Yep. Right. Yep. Another question here. We try and make it a point not to accept partial payments from roommates. If one roommate pays and the other is late, do we charge the full late fee on the full rental amount or the balance? Well, the balance would not be right. Depending on when it happens. And that's sort of the real problem with this law, is that it removes landlords' ability to automate this process. I think before this law, it was very easy to set your software and forget it. But now you have to be involved on a monthly basis in a very real way with determining how much of a late fee should be charged, and whether or not it's appropriate to charge 5% of a certain amount. With regard to a roommate paying a partial amount, if your practice is to not accept it, then I think that makes it very clean and easy. If you do accept it, then our recommendation at this point is that you can charge 5% on the full amount of the monthly rent. That may change as the courts interpret what this law means, but for right now, that's our recommendation. All right, and finally, our recommendation is to keep in touch. We think you have our information. Please keep in touch with us. Look, this is a changing law. We know that the way it's interpreted by both the Landlord-Tenant Court and the Court of Appeals will eventually the Court of Appeals will be important. It will change the meaning of the law a little bit, or at least define and clarify it. But we think the Landlord-Tenant Court will probably be out in front of this. Will probably create an informal practice that the civil judges who sit in the Landlord-Tenant Court will all follow regarding the amount, if any, of late fees that are permitted in future failure to pay rent cases. So if you have questions, look, we always tell you this. For our clients, pick up the phone and call us. We don't charge for routine questions, so pick up the phone and call us. And if you have a question about this late fee bill and what it means for you in terms of what to do next month on your ledger, it's better to try and get it right on the front end than it is to try and unwind something that was done incorrectly. And someone's asking, how can you get a printout of our pamphlet? I think that's PowerPoint. This will be posted, I think, to our website. We'll get with our folks here at Alton Kerman, and I think this will be posted to our website at some point, hopefully later today. And there we are. There's our contact information. In case you want to get in touch with us, those are both our office direct lines. Those are our email addresses. Email probably may be the best way to get us, since we're both so frequently in court.
And we can start, if you have questions that you've been holding on to, we'll leave the block open here for a few minutes. We just had one come in. Our current leases state that the late fee is 5%. Specifies a specific dollar amount for the rent charged at the time of the lease signing. Do we need to send addendums the following year after a rent increase, or will the 5% specification be sufficient?
I think that you can probably make the addendum part of your rent increase, and that will make the 5% late fee provision applicable. But I think, as I said earlier, I think that if you're charging 5% now and it's pursuant to a lease agreement that doesn't specifically track the language in this statute, that you do need to send out the addendum now to your tenants to make sure that they're aware that you are now complying with the newly created law in terms of how you charge late fees.
We currently auto charge 5% on any rent balance equal to the full rent amount. Should we change this? On any rent balance equal to the full rent amount.
Not sure that I understand the question. It sounds like late fees on late fees.
And we can differentiate between 5% of the balance due and 5% of the monthly rent. I believe our recommendation would be 5% of the monthly rent.
Yes.
If I'm reading this question correctly. And feel free to clarify. Like I said, we'll leave this up for a few more minutes here.
How long will it take to receive a copy of the addendum from our office? Call us, email us. We've got the addendum drafted. We also want to share the invoice with you that you should utilize when tenants fail to pay a late fee. And we want to make sure that it's properly tailored. It shouldn't take very long. Right. The addendum is pretty much ready to go in the can, but we will want to tailor it to your lease so it talks to your lease and your lease talks to it.
See if any more questions come in here. We've still got a few people.
Yeah, so feel free to send in questions if you have them. Feel free to get in touch with us via email or by phone. Email is probably best, as I said. And you know, it's not the most pleasant law, obviously, for landlords, but you know, we'll try to help you through it as best we can.
Do you have any more questions?
Oh.
off topic, can you charge court and writ fees to tenants' account? I know you cannot evict for the balance, but can it be charged? Court fees, so $23 in our filing for tenants and $8 for each additional tenant, yes, are part of the amount that a tenant must pay to avoid being evicted. Additionally, the writ fee, $18 at the time the writ is obtained, and another $195 at the time that the marshals appear on site to conduct the eviction, are amounts that tenants have to pay to avoid being evicted. This law doesn't address that, so those can still be charged. They can be added to a tenant's account after the time that we've filed a form with the court called a Form 6.
Right. And if you were at the seminar, or if you weren't at the seminar, and you have any questions at the time of eviction about the amount that you can lawfully charge in order for the tenant to redeem, give us a call.
Right, and that's sort of a good segue to the next point. We're going to be doing another seminar in December. We're still working on the specific date, but please be on the lookout for information about that seminar as well, because we'd love to have you guys attend again and see you in person as opposed to just appearing on the screen. So the PowerPoint, will it be available, Jennifer, today? PowerPoint will be available on the firm website today. So be on the lookout for that, and then be in touch. And thank you guys very much for attending. And we're going to go ahead and sign off.
All right. Thank you, everyone.